And welcome back to Risky Times. I'm Stephen Karras. I'm joined today by Chris Kirkblythe from LBS Legal and Mike Chard of Web for Law. So in relation to systems, clearly it's important, bearing in mind we've said that the nature of the information that they hold being highly sensitive, as being attractive, the fact that over 3,000 attempts are made regularly.
And I would
to
imagine
steal
that's
information
for each inbox.
Then,
Yes.
Yeah.
then if we look at the safeguards, or at least the requirements within the profession or expected of solicitors to put effective systems in place, when you look at the Data Protection Act, the requirement is to have appropriate systems to protect personal data. And this term appropriate, and in meeting that appropriateness, you need to base it on your own judgment and the kind of level of protection that you adhere to. And I find that many firms aren't really sure whether or not they have appropriate systems in place. They're just hoping that they have. How do you think firms need to assess their own IT systems or their own data protection systems generally in order to safeguard appropriately their clients' personal data?
Well, I think you have to start by acknowledging that law firms come in a whole host of different shapes and sizes, from many thousands of employees to kitchen table operations and everything in between. So both the data protection legislation and the code of conduct allow you to take account of the size and structure of your organisation. The one-man band lawyer, as a general rule, or this small office with 2 or 3 employees, will not be required to have the same sophistication in their systems as a City of London or international major legal practice. However, in certain circumstances, that one-man band may be required to have very sophisticated systems. If, for example, that one-man band is a childcare lawyer specialising in incredibly private, sensitive, personal information of children, then the degree of sophistication required would be high. The point is that the operation of the law firm has to be properly risk assessed, and certainly in the experience of LBS Legal, most law firms don't know how to carry out that initial risk assessment, and most simply don't do it. And even those that do it often fail to document it properly, so that in retrospect they can't prove that they did it, which of course is just as important. So there is a whole skill set required in carrying out a proper risk assessment of the vulnerability of data, the risks to client confidentiality, the risks to legal professional privilege, properly understanding those risks, and then putting in place proper systems to mitigate those risks and to bring those risks within acceptable parameters. And that is a skill set which the legal profession needs to acquire double quick.
And why would that be? Why double quick?
Because the consequences of getting this stuff wrong are just so horrendous. In disciplinary terms, in reputational terms, in financial terms, in legal terms, there's criminal offences littered throughout this system. There are regulatory offences, and because solicitors owe a fundamental ethical duty to their clients to protect that information. Our entire system of government in this country, our entire belief in the rule of law, depends upon one thing, and that's that individuals in trouble can go and talk to their lawyer and know that their lawyer will not betray their confidence. And without that, as a society, we don't have much left. It's very, very important, and it's an ethical and moral responsibility. It's also a legal and regulatory obligation, and it's one that lawyers always have taken seriously, and need to now adopt that seriousness into a more technically complicated age.
I don't think any solicitors, speaking on their behalf, most solicitors would say that they never intend to lose their clients' files, and if they're stolen, they would even see themselves as sort of partly victim to that. Cars get broken into, files get stolen. We know there have been plenty of instances where these kind of things occur. People get broken into, they themselves in some turn are a victim. So they're saying that they would say that there's only so much they could do, and I think it is important that that solicitors understand that perfection is not the required standard. That they've taken sufficient measure, and they can demonstrate that they take their commitment to client protection seriously by way of their systems, as you just said there, Chris. New data protection legislation coming in 2017, which is intended to put greater power on the data subjects, in other words, people who's got data held about them, to control who has access to their information and limit that access as well. Now, clearly, solicitors at the moment enjoy that privileged position where they can obtain quite sensitive personal data, but it must be appropriate and not excessive and processed fairly and lawfully. So I guess the question is what would constitute an appropriate amount of data gathering if these limitations are put in place for solicitors who have otherwise enjoyed almost unlimited access to their clients' information?
Steve, this is the big question. And the honest answer is, we don't know. Because although the new legislation is due to come into force in January 2015, as we speak, the final decision on how much information should be obtained and how long it should be retained is still a matter for debate. And the current situation is that, just as in our Houses of Parliament, currently there's a committee of members of the European Parliament who are sitting down and discussing this exact issue. And we don't know what their decisions are going to be, because we have a conflict. If you say to a lawyer, you need to make sure you gather as much information as possible to make sure that anybody you're dealing with is not doing so with the intention of committing a criminal act.
Such as mortgage fraud or money laundering.
Mortgage fraud and money laundering.
Yep.
Yet at the same time, it's being said, well, when you collect that information, you can only store it for a short period of time, and then you have to destroy it. So then if in due course the question arises, well, why did you ask this question? What was the purpose behind this transaction? What have you done about it? And you turn around and say, well, I can't tell you because, in fact, in accordance with these rules, I've destroyed the information I've collected. Yes, you're then left in the situation where you're damned if you do, and you're damned if you don't. Okay. What we do know is this: if a breach occurs, then the proposal is that for every individual breach, a firm can be fined up to 5% of its turnover for each offence.
Wow.
All right? And if you imagine you're in a situation where you have a continuing failure in collection of information, and that goes on for a period of time, you might be dealing with 200, 300, 400 clients and easily commit 400 or 500 breaches without even realising it. 500 times 5% of turnover, this could wipe you out. Okay? And the other angle to it is that inevitably when such breaches occur, for whatever reason, whether it's mortgage fraud or theft or money laundering, then there's a claim on the solicitor on his professional indemnity policy. And the insurers have to respond to that. They have to meet that claim, even if actually the solicitor should have known better and handle things in a different way. So what's the consequence then for the lawyer? Well, the insurer will say, okay, I've got to pay out £150,000 because there's mortgage fraud. Right? And what do you think happens the next time that the solicitor comes along and says, can I have a new insurance policy for my next year?
Premium.
And the answer, your premium goes to the roof.
Yeah.
Right? And the other impact that it has is even if the insurer meets the claim, if you have not taken the appropriate steps to cover yourself as any reasonable person would, the insurer is able to say to you, well, even though we've had to pay out this claim, we're now going to ask you for an extra portion of policy, of premium, because we've had to cover something we shouldn't have had to cover if you dealt with things in a sensible way. So there's potentially a double whammy that will come towards you. But I've seen from personal experience situations where lawyers have effectively found their firm has been wiped out just because of one claim. Yes?
Right.
Okay.
Absolutely.
So
It's serious. So it's serious stuff, Steve. Okay? It's serious stuff.
And
Thank you.
we should probably also point out that this whole issue is about to become more challenging and more complicated. But it's already today an issue which lawyers don't handle particularly well.
Yes.
We're already behind the curve. And the curve is about to move again significantly. So, for example, when it comes to the destruction dates, in most law firms, even of considerable size, there is chaos. There is usually a set of paper files, which still exist, and which are usually destroyed more or less when they ought to be. Although even that statement in itself may be a little generous to the profession. There is then usually an equivalent electronic file, which exists somewhere within some form of case management system. Now, those are very rarely destroyed on the same day that the paper file is destroyed. There is then usually a third file, which exists in email correspondence, which is probably never deleted until somebody's server dies, and then it's probably lost prematurely. So this whole requirement to destroy client data on an appropriate date is just simply not happening. And that's something firms really need to get a grip on.
Yeah, and can I just say, as cut across there, what most lawyers understand is that they hold the data. But what quite often they forget is the data does not belong to them. The paper file is not the solicitor's property. It's actually the property of the client. The client has paid the lawyer for that information. There are certain exceptions to that, which are pretty logical, internal memos, bills, certain bits of the information. But the bottom line is that paper file belongs to the client and should not be destroyed without their consent. Now, even if there is implied consent to the destruction of it, bearing in mind it's now held in different forms in different areas. Right? I've seen a situation where people have, as you say, the server dies, the computer dies, and then the firm has to dispose of that machine. But do they do it in a way which actually complies with the data protection regulations? Because logically, what in fact is supposed to happen is the actual hard drive inside that computer, which is pretty solid, right, should actually be physically crushed. Yes? Okay, and there are specialist firms that do this. But so often you have people who dispose of these the bits of kit, right? Their computers or their printers. There's all sorts of various things which store information even though they appear to be electronically dead. Yes, right? And unless there's a safe disposal of the data that they hold, that in itself is a breach of data protection acts. Okay, so there's a whole range of issues. It ranges from how long you keep it, what the documents are, how the documents are shredded, if they're shredded, are they all shredded, is there electronic information, how is that stored, how is that destroyed, how is it dealt with in a secure and safe way. And the danger for the lawyer is that it only requires one of those machines to get into the wrong hands for whatever reason, and suddenly the Information Office Commissioner is going to be knocking on your door. And if you want to know what sort of thing happens, well, you ought to be one of those health authorities which we read about in the press, where there's been files that have been found on a skip somewhere or tip or whatever with patient records in, and there have been examples where health authorities have been fined £500,000 for the failure to keep that information.
I think the largest fine to date, 325,000.
325,000. Okay, so arguing about £100,000 or so, to be perfectly blunt, I really wouldn't want to be levied with a fine of £300,000.
I wasn't correcting you there. I was just saying that, that's this precise figure, which is a very lot. It's a lot of money.
And of course, for a lawyer, that's not the end of the story. That's the start.
That's the start.
Story.
Yeah.
Because the next thing that happens is the Solicitors Regulation Authority pick up on the Information Commissioner's Office judgment.
Yes.
And they then will have a go.
Yeah.
And then your insurance company are going to start asking questions. If you have any panel memberships with lenders, etc., there are certain duties of disclosure, and it just becomes a snowball, and it just gets worse and worse. And even if the fine's only £50,000, the ultimate cost to the owners of that law firm will be many times that, if not completely catastrophic to their personal financial position.
Yes, and the bottom line to it is that when or if a law firm is fined for that action, actually it's not covered by your professional indemnity insurance, because if you committed in effect a criminal offence or a quasi-criminal offence and you're fined, you have to pay that yourself. Your insurance company doesn't cover that, because it would be contrary to public policy. Just like you can't insure yourself against being fined, right, for driving at 125 miles an hour. Right? You can't cover it because it's effectively a fine, and you can't protect yourself. So if there is a fine from the Office of Information Commissioner or whoever it is, you have to pay for it out of your pocket.
And then, of course, there's the Ombudsman as well.
And there's the Ombudsman as well.
Yep.
So
there's your defence costs.
And your defence costs, right? Which also these days aren't necessarily covered by your insurance.
Who'd be a solicitor?
Who would be a solicitor?
Who would be a solicitor these days?
Who'd be a
It's a very
solicitor?
good question.
It's a very good question.
Well,
in fact, I think there was a survey recently when solicitors were asked the question, would they recommend the law to their children?
Yes.
And it was in excess of 85% said no, they would not, which is very sad.
Yes, and in fact, that's exactly what happened to me. My daughter said, "Dad, I'm thinking of going to to become a solicitor like you." And she said, "What do you think?" And I said, "Don't." Right. So she didn't, and she became, in fact, a chartered surveyor, who, by the way, are also regulated in not dissimilar ways, but at least they're in a situation where they don't have exactly the duties and responsibilities of lawyers, because in the end, surveyors look at properties. What they don't do is they don't hold money. Yes?
If you asked the majority of chartered surveyors what their top 10 worries were, I doubt many of them would say that they would name their regulatory body.
Yes.
If you asked most lawyers what their top one worry is, I suspect they would say it's the burden of regulation.
Yes.
If you're a solicitor and you're watching, get out now while you still can.
Open a cafe.
Yeah.
Yes.
Open a cafe, sell coffee.
Yes.
Okay, thanks Chris, thanks Mike. We're going to take a quick break now. Join us again in a few minutes on Risky Times, and we'll be chatting further on this very, very important issue.